Well, chances are your company has a lot of at-will employees. So with Georgia, South Carolina being a right-to-work state, and we have an attorney that handles various situations in both states. Brian King, how are you?
I'm doing well, thanks. Thanks for having me.
Sure. I know there are certain types of employees that are under what's called non-compete agreements.
That's right.
Before we get started on the enforceability, what types of employees have you come across that are being asked to sign this?
Well, sales employees, because they've got a lot of contact with your customers, and so if you don't want them leaving your employment and going to work with someone else and taking those customers with them, so sales employees is probably the number one.
Makes a lot of sense. Yeah. And there's always a question about. I know when I was in the TV news business, boy, we couldn't go to another station within the same TV market for a period of, and I always thought, well, that's fine if I want to go outside the area, but what if I want to stay in Augusta? What seems to be the right term that is fair?
Right. Well, the enforceability of non-competes is a big issue, and I get asked that all the time by both employers and employees. And so, traditionally in Georgia, the non-compete agreements weren't enforceable to the same extent that they are now. Georgia actually had a public policy against restrictions on employment, or someone being able to go to another job. And around 2011, that changed because Georgia passed a constitutional amendment and then several statutory framework for non-compete agreements and what they had to contain and how they were going to be enforced. And so once that happened, the Georgia courts have now been enforcing non-compete agreements to a much larger extent. So it was a sea change in that realm of the law. And so the restrictive covenants, so non-competes, have to be reasonable. The restrictions have to be reasonable, and the way that the courts look at those restrictions and determine whether they're reasonable, they have to be limited in scope. So the scope of the work that is being restricted. So it can't just be you can't go work for anyone doing anything. It has to be limited to what that employee was doing for that particular company.
And you mentioned sales, so let's just say I said media before, let's say someone is in media sales and they want to go sell copy machines in our town. Is that okay?
Right. If it's something completely different and the employer where they're at right now doesn't do that type of work,
okay,
then there should be no restriction on them to go do that work in another area. So So the non-compete provisions also have to be limited in geography. So as you mentioned, this particular area, the CSRA, or you can even limit it by county. Say, Columbia County, Richmond County, Burke County, that sort of thing. Or you can do it by square miles, or you can do it by radius. So you can say a 5-mile radius, 10-mile radius, something like that. And it has to be restricted to the area which that company is doing business in.
So if someone was selling cars in Richmond County, Georgia, on Washington Road, and they wanted to do the same thing, but maybe it's in Aiken, or maybe it's a little further into South Carolina, that potentially could be okay?
Well, potentially could be okay into South Carolina if, as you know, the CSRA, we're so, it's just the river dividing South Carolina and Georgia. Yeah. So a lot of times the companies do sell to, Aiken County and Edgefield and that sort of thing. So it could be enforceable as long as the company is selling to that area. But it wouldn't be reasonable for them to say, well, you can't go sell in Kentucky if the company has never been selling there.
Sure.
And then also to be a reasonable restriction, it has to be limited in time. And as you were referencing, with an employment agreement that has a non-compete provision or a non-compete agreement, it has to say that you can't do this work for X amount of time. And typically what's been upheld by the courts is a 2-year limitation. So it can't go beyond 2 years. But anything 2 years or less would be considered reasonable in an employment context. Now that can differ if it's a sale of a business context. So let's say someone is selling their business and they agree to a non-compete for a period of time so that they won't get back into that business after they've sold the business.
And you know what? That happens. I mean, even with me, with Buzz on Biz, years later,
Right.
I'm doing something similar. But you do see, I know someone that was in the IT space, sold a company. He's restarted under a different name, but apparently it met the scope and time and distance and all that.
Yeah.
So it does happen.
Yeah, and in the sale of a business context, the courts have upheld 5-year restrictions and said that is sufficient and or satisfactory. Beyond 5 years has been stricken down before, and so you've got that longer time period of restriction with the sale of a business context.
We're continuing with Brian King, who services clients in Georgia and South Carolina, offices in Atlanta and Augusta. Online, businessattorneylaw.com.
Right.
Businessattorneylaw.com. Have you been witness and have had to go to court on these kinds of things before?
I have.
And how has the judge typically ruled in this situation?
Yeah, well, it really just depends on the situation and what's going on in that case. But I mean, I have represented, I've represented people, in employees wanting to go work somewhere else, and I've also represented employers who were saying, "Hey, you can't go work somewhere else, and you can't go work for that particular company because they're a competitor of ours." And so it's, you really have to dig down and look at the facts and circumstances of each case and what that employer was doing when they, left the company and what they're doing now and how competitive is it, that sort of thing. And, but I also, I draft a lot of the non-compete agreements, for my clients, and it really does take some care. You have to draft them pretty carefully, or otherwise they're not going to be enforced. And so, and because I've had that litigation experience, with those provisions, I've been able to craft my provisions very tailored to make them, a lot better chance of being approved by the courts versus being stricken. So
and then are there times at the end of the day, if the employer says, "I want you to sit out for a year and a half," and the employee says, "I want to sit out for 6 months," I mean, is there just a win-win somewhere?
Well, sometimes, I mean, sometimes they do settle on some time frame that would work, and sometimes the employer may sue just to stop the employee from being able to work while the litigation is pending. Sometimes by the time the litigation is over, the restrictions run. And so in my documents, I usually have provisions in there that say that it will toll while the litigation is pending, and then it will start back after the litigation is pending. So there's provisions you can add in there to give the employer more protection and stuff. So, it's a little bit of gamesmanship goes on with the litigation when it comes to because you're dealing with, say, employee that's gone to a competitor, and if that's going to hurt your business, sometimes they do what they can to try to minimize that. But they take a risk though, because they're going to court, and they could get slapped on the wrist by a judge for bringing something that wasn't really something they should have brought.
Fair enough. Well, he is Augusta Business Daily Attorney, Brian King, and it is businesslawattorney.com for the website. And boy, I think this is the first time you've been back in the studio since there's been a few changes. What do you think?
I think it's good. I like the lighting. It's better than it was before, and it's businessattorneylaw.com. Yeah,
that's what I said. businessattorneylaw.com. Well, we are very pleased to mention about, the podcast folks, and you can get on up, if you will. Ode to James Brown, getupproductions.com is the website, the umbrella company of the podcast studio here, and all of the information is up on the screen.